Well, good afternoon. I was told by Jim, since weather cleared up, that I'm supposed to give you back about 20 minutes of my 30, but he may have some conference with Judge Green to go to, the golf course, maybe. But no, there was a story a while back about an old boy that stumbled out of the bar and couldn't find his keys, could barely make it into the car, and Joe Ranger Ted was there looking for his next arrestee victim. And sure enough, he waited. The guy committed a traffic violation. The man failed all the sobriety tests and hauled him down to the jail. Failed all the sobriety tests at the jail. Got him there for the breathalyzer test, and he blew a .00. Well, Joe Ranger Ted didn't care. He just put him in jail, and he got magistrated the next morning. Asked for an appointed counsel, and they got appointed counsel, and they finally were able to get the case dismissed. And the prosecutor finally, or somebody asked the police officer asked the prosecutor, well, what was the problem? He says, oh, well, the guy was apparently the designated decoy. So, good appointed counsel can root those things out and ascertain those matters. Now, this thing works just like this, right? Forward. And what is a segue into what we're doing here with the from Jeopardy to this. A lot of you'll see this, some of the stuff you just saw again. Hopefully, having heard some of those answers now, it'll maybe make a little bit of sense as we go through this. And basically, that's an outline there of what we're going to talk about. The just a matter of resources there for you. Some of this stuff you may just want to consider. Some of it is more apropos in the sense that it is a state statute that dictates what you need to do and the steps that you need to follow. And we'll go through some of these. And basically, just from, did that go too slight? Yeah. This is the nuts and bolts of the plan. I'll get hold of this machine here in a second, figure out how to make it work. But then once you get your good plan ready to go and you're implementing it, the cracking those rusty nuts with a crescent wrench sometimes does take a little WD-40 and elbow grease to get it done. But once you get a well-oiled plan and get it going, it does tend to work very well. But basically, what the secrets to this are, documenting and recording everything that you're doing as part of the plan, screening the defendants actively, not passively. Don't just hand them a piece of paper, and we'll talk more about that in a minute. Appointing counsel proficiently, and monitoring compliance. That's of the attorneys that you appoint, making sure they're doing what the code requires them to do. All these types of things will help you enhance the public trust, as well as instill integrity in the entire system so that we avoid the potential exposure to our jurisdiction regarding issues such as Rothgary or Willingham. And this is one of these matters just as a resource that you might want to consider. It's in your handbook, a copy of it, the ABA's 10 principles. As well, there is another in your handbook, I believe, in page 79, specifically dealing with juvenile issues and offenders. The National Juvenile Defender Center's 10 core principles is what they call it regarding appointed counsel. So you may want to use these as a resource. The ABA's principles, basically in regard to independence, they talk about maybe utilizing a nonpartisan board to administer the program or to set it up and monitor. In regard to the coordination between the defense bar and or public defender's office, if you have that, the private bar, they basically say that you should even have an administrator, a full-time administrator, that is a lawyer that would know the issues that are involved to help drive the bus. In regard to expediency, the ABA sets up a 24-hour guideline. Obviously, here in Texas, we have a 48 for magistration, then 24 for after request. As well, then just some of these are seemingly upfront and don't need a whole lot of further elaboration upon, but just having adequate conference time and space. They say that the defense counsel is set up should have the free and full exchange of procedural, legal, and factual information, basically creating a parity with the prosecutor's office in that regard as well. controlling and managing the workload, the ABA suggests that you have, for felonies, no more than 150, misdemeanors 400, and juveniles 200. And I think that is cited in the footnote there. 6 and 7 are pretty straightforward. Basically 7, in regard to continuous representation, there is a dichotomy that from the point of appointment, defense counsel should be appointed and represent the person through the end of the trial. If convicted and there needs to be appellate counsel, that appellate counsel, once begun, should finish the drill and complete his or her task. In regard to the parity of resources, again, with the prosecution office, it deals with salaries, with numbers of personnel, with other forms of resources that the ABA suggests as a standard, there be that type and level of parity. In regard to the accountability, auditing, and appraisal, that there's a certain efficiency standards that should be met, as well as competence, for obvious reasons. But more specifically, in regard to matters that are codified by our legislature, in the Government Code, Chapter 71, specifically 060, there are 10 policy standards that you can look at, and you kind of just look at those. Some of them mirror, at least as far as a breakdown, those ABA codes a little bit, or that ABA suggestion. Now, to get a little bit into the meat of it, in Article 1.051, in the right to counsel, A obviously says that you have the right to counsel, and B basically gives us the definition from a statutory construct point of view. What is indigent? Well, it's just simply not being able to financially employ counsel. And then C being the right. When do you have that right to have counsel appointed? And it basically is if there is an offense that has the potential of punishment of confinement, felony or misdemeanor, matters not. If you're indigent, if you're entitled to it, and you must, as a defendant, request it. And obviously there are other procedures in our law that y'all have heard about today and have probably known about before then, that we have to make sure they're informed of their right to even request. We'll touch upon that in a little bit more as well. And when does the adversarial proceedings begin? When are they initiated? Rothgary ascertained that for us. Even that 1517 hearing in Texas, the magistration procedure itself is the beginning of the adversarial judicial proceedings. So shortly thereafter, there must, as the Supreme Court put it, within a reasonable time frame, if they've requested it, if they're entitled to it, if there's punishment that's going to be up to, potential confinement, that then there should be counsel appointed, and under the Texas statutes, respectively for small and large counties, 3 or 1 working days. That then, just trying to hit the high points here, in subsection J of 1.051, the indigent defendant who's not in custody, what do you do with that individual? Again, the appointment is required after the first of a court appearance or the beginning of the adversarial judicial proceedings. Again, that is going to be that 1517 hearing. And then if you'll notice, in that particular section, there's not a time constraint, not a requirement. But I would suggest to you that you have a guideline from when they're in custody. If they've requested it, you need to probably get them counsel. That could almost mean immediate. You can read into that what you choose, but I would suggest that everybody would be best served avoiding liability for your jurisdiction if you try to follow the 3 and 1 working day perspective. As to Article 1517, what are the duties of the magistrate? Obviously, it has to happen within 48 hours, and then there are the shalls. These are the things that the magistrate has to do. Admonishing, there's a number of rights, depends on how you count them, 7 or 8 or maybe even more, rights that you have to be informed of as a defendant. That then you shall inform them of their right to request, as I mentioned just a while ago, appointment of counsel if they are entitled to it, etc., and that they shall inform them of the procedures as to go about that request, to effectuate that request, and shall ensure reasonable assistance. And what is that? Whether it's the magistrate, his or herself, assisting, or whether it is a designee of the court, or whatever is appropriate. But there are some suggestions we'll talk about as well in what is best. And you've already heard earlier this morning from Lubbock and how that they're doing things, and also from Tarrant County how they're doing things as well. And then the shall admit the person to bail if it's allowed by law. Then the one thing that you have to be careful of, that the law of unintended consequences in the very next sentence of 1517 now reads, right after the last one there, shall admit the person to bail if allowed by law, the very next sentence reads that a recording, not just a record, but a recording of the communication between the arrested person and the magistrate shall be made. Now, is anybody complying with that? It's automatically being a recording? That's good. Well, I will tell you that there's nothing wrong with that, making that recording. That's what the statute now says. I'm not sure that was the intended consequence of the legislation that was passed in the 2005 legislature in House Bill 2120. Really what they were trying to do was they just moved some language regarding closed-circuit television so that they could better define an electronic broadcast system. I hope you can see that up there. I was afraid that might be too small, but this is the legislation, the relative portions of it from House Bill 2120 that, as you see there, right above the red crossed-out language is that language I spoke about. Admit the person arrested to bail if allowed by law. Then they struck the sentence about closed-circuit television. And then you have the portion there that says a recording of the communication shall be made. This is at the bottom of that legislation where they basically redefined and moved the language about closed circuit just to the bottom of Section A. And so it just basically got redefined and moved. The bill analysis there certainly doesn't say they wanted everybody to be making a recording of every time. They simply were redefining, and that's what the purpose of the statute was for, just redefining closed circuit and making conforming changes. But what was in fact intended by the legislature throughout the Senate Bill 7 process was that there is a record, not necessarily a recording being required, but at least a record of some form or fashion of certain things. So what was in fact intended in 1517 subsection E is to help keep everybody's you-know-what's out of hot water. If ever there's an issue that arises, that if you have a record of these things, you will be probably in good shape. That if there is a record of the magistrate informing the person of the right to request, that the magistrate asked the person whether they wanted to request, and then third, whether the person requested the appointment of counsel. When I was preparing for this talk a little bit, I talked with Jim and said, how best can I help the task force and counties at the same time get to a better point of indigent representation? So we talked about a few points, and this is one of the things that Jim felt like would best assist counties in making sure there's several takeaway points that we want you to be able to leave here with that will help the task force maintain appropriate records as well as help you avoid liability. Then Section F also talks about a record required under that previous section. It may consist of a number of different forms. It doesn't have to be that video or audio recording. It can be, but it does not have to be. In 2604 of the Indigent Defense Plans and Procedures, this is talking a little bit the nuts and the bolts of what needs to happen, that the judges of the appropriate courts by local rule shall adopt and publish. Where you publish them, I don't know. But it says you publish them. And that courts shall use a rotation system unless there are several different options. If you have a public defender program, you need not use the rotation. Or if under G and H, you have an alternative program approved by the presiding judge of your administrative region. Or if in felonies, that's kind of an interesting provision right here, that if you have a felony case, there may be somebody, and this is probably for the Loving County Marshal, in the administrative region, the 9th region, I guess that's the 9th out there, that out in Wink and Kermit, Texas, population 64 or 67, depending upon which direction the wind's blowing, I guess, out there. They may not have adequate counsel nearby. So if it's in a felony matter, you can go anywhere within the 9th region. Go to Lubbock, go to Amarillo, find someone that's capable, that's willing to come down, be appointed, and handle that case. And that presumes, I guess, that they otherwise would qualify the minimum qualifications, but they need not be on your list. So that you could go beyond the next 5 on the rotation to do that if you needed to. But in so doing, that if you're going to deviate, again, one of the takeaway points is make sure you're making a record of the finding of good cause if you're going to deviate in doing so. One of the statutory findings of good cause is if you have a defendant who does not speak and understand the English language. That's provided for you in statute, just like somebody within the judicial region, administrative region for felonies. Those are statutory outs for you. If you have to use them, use them. As well, then, under B, the appointments must be made only by the appropriate court or the court's designee. And then in those under a rotation system, that the appointments need to be fair, neutral, and non-discriminatory. That's the language that's used there. Further, in 2604, the appointment list shall contain attorneys who have applied, who meet the local qualifications and meet the state standards as well, and then approved by the judges of the appropriate courts. And then you can use multiple appointment lists, whether you're dealing with misdemeanors, whether you're dealing with felonies, basically graduating them from one to another based on the experience and ability of the attorneys, as well as the complexity of different types or degrees of offenses. In 2604G, if you're going to use an alternative program, you note that the statute says it must be county-wide. It can't be per court or such as, different district courts, different county courts at law. It must be a county-wide program. And then that alternative program also must be approved, number one, by 2/3 vote of those appropriate judges of that court. As well, then, it must be approved, as was one of the questions in Marshall's Jeopardy game, by the presiding judge of the administrative judicial region. And then Section G, sub D, also talks about the alternative program must ensure a little bit different than using appointments from a rotation, but that the appointments are reasonably and impartially allocated. I'm not sure if there is a difference, but that is the difference in the wording of the statute. In J1 of 2604, this is where we get into the monitoring the compliance of counsel. This is what's required of appointed counsel, is that they at least contact by fax, by phone call, sending a secretary, somebody, to say, I'm your lawyer. At the very least, by the end of the next working day, and then interview them as soon as practical. And that under K, it provides a mechanism for courts and court administrators to be able to purge someone from their list, as well as get someone off a particular case if they are violating that J1 provision. And then in L, talks about the procedures that must include the financial standards for determining indigency. And then there's some specific wording that is regardless of whether the person remains in jail, is unable to make bond, or they've been released from custody for whatever reason, on bond or a non-prosecution affidavit, or if they requested, if there's not been an official declination by the prosecutor, they're probably still entitled to an attorney. Don't get yourself in a Roth-Gary situation. But then there's a reference there back to 1.051, the broader definition of indigent, someone who simply cannot financially employ counsel. Then Section M continues. There's a list of factors to consider. I'm not sure I completely understand this language where it says that you may, in regard to indigency, you may not consider whether the defendant has posted or is capable of posting bail, except to the extent it reflects on their financial circumstances. I'm really not sure I quite understand that, but that is the language of the statute. So just be aware of that. And then both N and O of 26.04 require that the defendant requesting appointment of counsel swear to the truth. You can do that through a number of different mechanisms that are in the statute, by signing an affidavit, swearing before the magistrate, on video, however you want to document that, you can do that. And the statements given under that section, there under Q, it says cannot be used against the defendant, even though you've earlier warned them the statements can be used against them when you give them their rights. This statute specifically right here, this provision prohibits you from doing so, except for the purposes of prosecution under Chapter 37, such as perjury, aggravated perjury, tampering with a governmental record, that affidavit of indigency, if it's incorrect, you falsely filled it out, could subject them to prosecution under those provisions. Then under 26.05, regarding compensation of appointed counsel, basically under A, it talks about a fee-based system upon the amount of labor, the complexity of the case, the experience, the ability of counsel, etc., and that there needs to be a schedule of fees adopted by formal action of the judges. Again, I'm not sure what formal action is, just like I'm not sure what publish means, but basically I would suggest you follow other just typical posting requirements for an open meeting, have all the judges get together for coffee and donuts, and make formal action. Then, as to reimbursement of reasonable and necessary expenses, it includes mental health, investigation, and other experts. And doing so certainly not inappropriately. We don't want to waste the county's coffers at all, but yet it can certainly save you in the long run to avoid writs of habeas corpus, ineffective assistance of counsel claims, liability claims, etc. So a little bit of insulation, prevention to avoid pounds of cure can certainly be in your best interest. And there under G of 26.05 is a provision that authorizes courts to order reimbursement if the court finds that the defendant has some ability to pay. And we heard earlier today that that generally needs to be done at or before or near sentencing. So you've got to have that mechanism in place to do that before you get to the end of the case in creating your plan and implementing it. Then here is the elbow grease that needs to be applied in implementing your new program. Again, basically to ensure the efficacy of your program, document and record as much as you possibly can. And it's part of the reason why you probably need to have an administrator of some kind doing this in an independent type of a position, just from a logistical standpoint. But under Article 1517, we talked about the time and the date of arrest, or making sure that you do that within 48 hours versus the time and date of magistration. If you can document those things, that's only going to help you, that when that person comes back later on and says, I sat around in the jail for 6 weeks before I was even magistrated, you're able to rebut that. As well, document and record such things as under 1517E. We talked about those required documentations. In 1.051C and J, again, document the time and date of the appointment. Make sure you're aware of it so that you can make sure that ultimately you're being able to monitor whether or not counsel is doing his or her job to try to keep, again, the county out of hot water later with claims of liability, ineffective assistance of counsel, or otherwise. Also document the good cause, as we've talked about several times, deviating from that rotation, and specifically one, as well, the attorney compliance with the initial contacts, as well as having to interview the defendant as soon as practicable. In screening the defendants actively, again, as opposed to just giving them the piece of paper and expecting them to give you the truthful information, sign on the dotted line where it says, "I swear this is true." Nobody's read that to them. They've probably done it over in a corner somewhere. You think they're going to try to get by with more that way? Or if somebody is actually sitting there asking them the questions, one at a time, getting them to raise their hand, they may still lie to you, but they're a lot less likely to lie to you if they feel like they've got some face-to-face, somebody who is actively pursuing and asking the questions and not simply passively receiving information. And in order to establish appropriate poverty guidelines regarding indigency, as well establish that standard, there's a number of different ways you can do it. Pick a number, a reasonable number. If you want to, here's the website for the Health and Human Services Poverty Guidelines. I don't know how often those change, if it's annually or biannually, but you can, whether it's 100%, 125%, don't know what is an appropriate number, that's left up to you as a jurisdiction to create those objective guidelines. One of the questions that I put in here that I think a magistrate probably should answer or ask to make sure they get answered is, do you have counsel already appointed in other matters? We know a lot of these guys are frequent flyers, and so they come back and again, and maybe in the adjoining county they have other issues already going on. They may already have a felony going over there. It'll make it beneficial for both prosecutors, for the judges, for defense counsel, if everybody's on the same page. A lot of times things can be 1245 under the code to get everything to run together and avoid duplication of resources in prosecution and judicial resources as well. So that may be one question that I threw in there that you might want to ask. You could then appoint somebody counsel if you're in the same judicial administrative region to represent them in both places. And appointing counsel proficiently, that segues right into that. Again, just follow your plan. Once you've got the rust knocked off, got your plan well greased, follow it. If you've got a rotation system, again, make sure that the appointments are being made fair, neutral, and non-discriminatory. And that if you have an alternative program, the appointments are being made reasonably and impartially. A couple of different options that you can have there to maybe increase participation by the local bar. I would suggest to you that you might even create a way in your plan. You might be good attorneys out there that say, I just don't want to do criminal work all the time, but I want to do some public service. I want to give back to my community a little bit. I'll take maybe 4 a year, 1 a quarter. Create a method where that you can get them plugged in timely in accordance with their wishes to help you out with that. There are obviously other people that's all they want to do is criminal cases, and they want to have a critical mass, so they would like to have 6 cases a day or whatever. So, but find a way to best use the private bar and the resources that you've got. As well, we've talked about the administrative judicial region several times. Document your deviations, your good cause finding under 2604A or C if you have somebody that does not speak and understand the English language. So make sure it's not just the speaking issue at all. What other types of good cause might there be? Maybe they've represented someone in a prior case. We have our administrator that does this for us, that she'll look at them. If they're already in the computer, who represented them last time? That's good cause to deviate from the next 5 on the wheel. Maybe they represent somebody in another jurisdiction nearby. again, but you're going to have to get that information quickly, and that's best obtained from the defendant if they'll give you that answer with all candor. Likewise, maybe a particular attorney specializes in arson cases or something of that nature. You might create a system in your wheel, your rotations. It might have to be a part of an alternative aspect of your program that you get approved by 2/3. It's countywide. You go to your administrative judge to get that approved to run at the same time with your rotation system. If we have specialty type attorneys, could you do that? I don't know. I'm just throwing out options. Anybody else have other types of good cause finding that you've made or that you might rely on a regular basis? No hands? We'll go back to Jeopardy. There might be other forms of expertise. Maybe someone, if it's going to be a high-profile case, you might not want just anybody doing the representation. Just other issues come to light in those situations. That might be good cause. Likewise, again, we've talked about the appointment from within the region. What about in juveniles? A lot of times those situations come up in New Braunfels in Comal County, a medium-sized jurisdiction, if you will, where that you've got to get an attorney scrambling real quick to do that very first detention hearing when they got arrested the night before, some juvenile or whatever. You've got to document if you're not going to follow your rotation system. So what types of good cause can you think of that you might have? Well, this is the first person I could grab in the courthouse. That might be good cause. Have they represented the juvenile in other matters? We kind of have a protocol of methods that we go down that our administrator, and if they can't find someone because we're trying to schedule that hearing, we'll get somebody in there for them. In regard to monitoring the compliance, you got to monitor the annual CLE. Adhering to that post-appointment, are they acknowledging a receipt of the appointment? Or are you just faxing the appointment? How are you being sure that you know the attorney got the word so that attorney can go make the contact with the person within the first working day? And then interview as soon as practicable. As well, you want to follow that up to get somebody to confirm for you that subsequent interview has been made. By doing all those things that we've talked about, you will certainly enhance the public trust. Some of those policies and procedures that are in the code that are required under state law that we're doing, as well in enhancing the public trust. Suggest to you there might be ways, I'm sure you've thought of many, to verify the process. There is possibly a cost effectiveness in not necessarily verifying every single person that walks in the jailhouse door, whether or not they're giving you truthful information, but some form of a random selection, just so that the public knows that you're not just throwing the tax dollars at everybody that walks in the door to have counsel, to have experts, whatever the case may be. But there probably is a cost-effective return by implementing some system following certain standards. There is on the website some forms, indigency affidavits as well on the website, utilizing an Excel spreadsheet where instead of even filling out paper forms, that the magistrate or the court's other designee, whatever, is filling that information out online, very beneficial, very easy to use, and making a record of that. And then those forms that are on the computer that you can use, there's a couple of different things suggested there that you can verify employer and financial information that's given. Thought that I'd had is possibly, don't know, I don't think there's any case law that I'm aware of. Could you get an authorization from that defendant, create a form, just like when somebody tries to go down and buy a new car, that car dealership is going to give them basically money through GMAC or whatever, maybe not anymore, but they're going to run a credit check on you. So they're asking for resources being applied to them from the taxpayers. As long as they authorize it, I certainly think you could possibly get a credit verification, at least on a random basis. And just check that out. Now, I do not think that you could say, well, if you don't sign this, we're not going to appoint counsel. That's where the rubber may hit the road. So you have to be careful about how you utilize that, but you simply don't have to advertise that you're going to give them counsel if you believe they qualify anyway. Further, by doing so, we will not just enhance the public trust, it will certainly instill integrity in the system, avoiding those issues that come up, whether it's Roth-Geary or challenges, 15, 16 years down the road to appointed counsel in a case from 1991 in the Willingham issues. And so develop a plan, follow it, screen the cases actively, and document everything as much as possible, determining the indigency with objective standards. Make sure those are established in your plan. Find ways to appropriately, cost-effectively verify the information appropriately, appoint counsel, or obtain the valid waivers. Those issues there in 1.051 I didn't discuss. I knew Andrea was going to talk about them, but from 1178 of the last legislative session dictated those issues there. And basically, if they're going to waive counsel before a dispositive hearing, you need to give them an additional 10 days. That is the safe way to go. Again, document the good cause for any deviations from the plan. Monitor the appointed attorney's compliance in the process throughout, and pay the reasonable and necessary legal fees, and avoid those issues. I hope that this has been beneficial to you. There's my contact information, and I probably ran over time, so I apologize.